We the people. Simple, powerful words. Words that form, in fact, the opening phrase of our state and federal constitutions. We the people proclaims a government that looks to its people for its strength, vitality, and legitimacy. We the people is the foundation upon which we build all the freedoms and rights of our democratic society, including the right to a jury of our peers. We the people are citizens from all walks of life, taking time away from work and family, coming together as jurors. Honoring our call to duty, often making personal sacrifices along the way. We gather as a jury, hoping for wisdom and striving for justice, recognizing that our decisions can change lives. We bring forth the best in ourselves, and as jurors, we make a difference. Welcome, and thank you for answering the notice you received for jury service in Washington State. This is one of the most direct ways of participating in our democracy and is a foundation of the American justice system. For the next several minutes, we are going to go over in detail jury selection, how you were chosen, and what that process looks like, some basic procedures you may encounter in a typical courtroom, and your role as a juror, should you be selected to serve. We'll also discuss unconscious bias, as well as what impact your jury service could have on you, your fellow citizens, and the state of Washington. Let's get started. The goal of jury selection is to have a cross-section or representative sample of the community. If it weren't for people like you, we would not be able to achieve the constitutionally guaranteed right to a trial by jury. This right is included in our Bill of Rights. It applies to all criminal trials and many civil cases. You have become a part of this jury process because your name was selected at random from voter registration records, driver's license records, and state identification records. Your name was then placed on a list of potential jurors, and your answers to our questionnaires determined your eligibility. Jury trials generally take a day to several days to complete. In rare cases, a trial can last several weeks. There are many factors that may extend or shorten the duration of your specific case, whether a case is civil or criminal, the complexity of the case, and the number of witnesses. The judge will give you more information about this during the jury selection process. By now, you are probably beginning to feel the assorted pressures and emotions your jury service will place on you and your family. To some, it's simply a minor inconvenience. To others, it's a bigger disruption. If you believe that serving as a juror will cause you a major hardship, or if there is an accommodation that the court can provide to help you serve as a juror, please let the court know as instructed on the jury summons. Don't wait until the trial is underway. The first step in the jury selection process is questioning potential jurors. Jury selection may be conducted in the courtroom or remotely. The number of potential jurors may vary depending on the circumstances of the case. The panel will consist of more jurors than are ultimately needed for the case to ensure that the selection process is fair. Remember, we're trying to get a representative sample of our community. Whether you are assigned to a criminal or civil case, the process for selecting a jury is the same. As a potential juror, you'll be asked to swear or affirm that you'll answer all questions truthfully. The judge will tell you about the case and introduce lawyers, the plaintiff, and the defendant. Plaintiff and defendant are two words you'll hear a lot around here. The plaintiff is the party who begins the case by filing a complaint in court. The defendant is the party who is responding to that complaint. In a criminal case, for example, the plaintiff is the state, city, or county government, which begins the case by accusing the defendant of committing a crime. For this reason, you might hear the plaintiff in a criminal case referred to as the prosecution, the state, or municipality. In a civil case, the plaintiff and defendant can be individuals, organizations, or governments. The judge and the lawyers will question you and other potential jurors to determine if you have any knowledge or personal interest in the case, or if you have recent or significant personal experiences that might make it difficult for you to separate the events on trial from your own experiences. This process is sometimes referred to as voir dire. Some of the questions you will be asked during jury selection may seem very personal, but you should answer them completely and honestly. If you have a response that would be difficult to talk about in front of the whole jury panel, the court may be able to accommodate your responses being shared in a smaller setting. To request this, please raise your hand and let the judge know. Remember, the judge and the lawyers are not trying to embarrass you or unnecessarily invade your privacy. They're just trying to find out whether you or the other potential jurors have opinions or experiences that might prevent you from making an impartial or fair decision. It's important for the court to be aware of information about you that could affect your impartiality as a juror. If the questions from the judge and the lawyers missed something important, please speak up. During this question and answer period, the attorneys may ask the judge to excuse you or other members of the panel. If this happens, please don't take it personally. This is not intended as a reflection on you. Excusing selected jurors is how the parties and their attorneys participate in the selection process. There are two ways for the lawyers to ask the judge to excuse a potential juror. They may use challenges for cause and peremptory challenges. In a challenge for cause, the lawyer must state a specific reason for thinking that the juror would not or could not be impartial. Peremptory challenges are the lawyer's right to remove a juror without expressing any reason for doing so. Unlike the challenges for cause, the number of peremptory challenges is limited. If you are excused from this trial, you may or may not be placed in another group of potential jurors for another trial. If you are, you'll go through this jury selection process again. Now, let's say you've been selected for a trial. As a juror, you'll begin to see that court proceedings are careful and deliberate. It's intended that way. The crucial decisions you'll be helping to reach can have a lasting impact on the parties, so these decisions cannot be made in haste. There will be times when you will be asked to wait for a while. Please understand that the judge and court staff are working hard to keep these delays to a minimum, but there are good reasons for these delays. A pause in the action is often necessary for the judge to ensure that the parties receive a fair trial. The judge will attempt to handle these matters so as to minimize the time that you are kept waiting. By the same token, please be prompt in arriving at court each day. The trial can't proceed until all jurors are present. Whether it's a civil or a criminal case, the procedures and the participants in the courtroom are basically the same. There will be the judge, the lawyers, the plaintiff, and the defendant. Although in a criminal case, the plaintiff is the state or local government, and you will not always see somebody sitting at the plaintiff's table with the prosecuting attorney. You'll see court staff, such as a court clerk, and often a bailiff. Sometimes you'll also see a court reporter transcribing the trial, or the trial may be recorded electronically. You may also see an interpreter assisting a party or witnesses in the case. At the beginning of the trial, the lawyers have an opportunity to present opening statements. Here, they'll outline a general picture of what they expect the evidence to show. It's important that you do not regard their statements as evidence. The lawyers are advocates, not witnesses. In the next phase of the trial, evidence is presented. Evidence might be a witness's testimony or physical exhibits. Lawyers may object to evidence, and the judge decides whether the law allows it to be used in the trial. While the judge decides the law that applies to the case, it's your job to weigh the importance of the evidence or testimony allowed by the judge. For example, you will determine the credibility of the witnesses. To succeed at your job, you'll need to pay careful attention to each witness's testimony. Your memory of the testimony will be absolutely critical when you deliberate on your verdict at the end of the trial. Because your memory is so important, you may be allowed to take notes during the trial and to use your notes while you deliberate on your verdict. If you do take notes, be careful not to let that interfere with your ability to observe the manner and demeanor of the witnesses. These observations can be very helpful in determining your judgment on the case as a whole. You cannot discuss the case with other jurors until you begin your deliberations at the end. As each witness testifies, you need to assume that this will be your one and only opportunity to observe them and hear what they have to say. Do not expect that any trial testimony can be repeated for you. Listen carefully and take notes if it will help you remember things later. During the trial, you must shield yourself from information relating to the trial other than what you observe in the courtroom. For example, you will not be allowed to read news or social media stories about your trial or related topics, nor will you be allowed to investigate or research any aspects of the case through the internet or otherwise. The judge will give you more information about this. The judge will also take other steps to protect you from outside influences, such as cautioning the parties and lawyers not to have any contact with you outside of the trial. So don't be surprised if they avoid you in the hallways during breaks. You should avoid them too. Wear your juror badge to avoid inadvertent contact with someone who does not recognize you as a juror. If a party, lawyer, or witness does try to communicate with you outside of the trial, you should report this to the bailiff or other court staff, who will inform the judge. You are also not allowed to use cell phones or other communication devices during the trial proceedings and deliberations. The court will help you if you need to contact somebody. Finally, your family, friends, and coworkers will not be allowed to talk with you about the trial until it's over. This may be awkward for all concerned, but it's a crucial part of your role as a juror and must be honored and understood by everyone in your life for this short period of time. After all the evidence has been presented, the judge will instruct you on the law. The lawyers will present their closing arguments on behalf of their clients. They will discuss the evidence or lack of evidence and how they contend the law applies. Under our Constitution, everyone deserves a fair trial. That's why it's the court's goal in every jury trial to find jurors who will decide the case before them without prejudice or bias. Bias is a prejudice in favor or against one thing, person, or group compared with another. Basically, bias equals prejudging, in a positive way or a negative way, whether we're aware of it or not. You may have a deep-seated belief that baseball is a better sport than football. You may prefer strawberry to raspberry jam. These are conscious biases that are not inherently negative. However, a conscious bias can lead to harmful discrimination. For example, consciously deciding a person is not entitled to equal rights based on their race, sex, age, nationality, or religion is considered harmful discrimination. We're not always aware when bias is happening. This is what we refer to as unconscious bias. Researchers have found that unconscious bias is a part of how we all think and process information. It's something we all have simply because we're human. It's the set of automatic preferences deep in our brains that instantaneously influences our decisions and how we perceive people and situations without our conscious awareness. Unconscious biases have evolved to help us make efficient judgments with minimal mental effort, so we can feel comfortable, safe, and confident. We can't process all the information we receive, so without even knowing it, our minds create mental shortcuts and use our past experiences to help us make quick decisions. Here's an example. Take a look at this list of colors and try to name the colors as quickly as possible while ignoring the words. Now, do the same thing with this list. Name the colors, not the words. While it may take a little longer to identify the colors in the second list because we aren't relying on color-coded shortcuts, taking the extra time to take in and process more information is worth it, because more data helps us make more accurate decisions. This test demonstrates that because our unconscious biases are automatic, we use them to make judgments and decisions without even realizing that's what we're doing. But if we stop to consciously think about it, we might decide our initial hasty judgments don't actually fit with the information that's presented or what we really know to be fair. Here's another example of unconscious bias. When you first view this biker, you may instantaneously feel he is either an adventurous free spirit or maybe a rebel who's tough, abrasive, or even dangerous. The truth is, each of us will make instantaneous decisions or prejudgments about what type of person he is, even though we don't know him or have any additional information about him. In a trial, your decisions as a juror might have big consequences, so it's especially important to consider your own unconscious bias in order to prevent it from painting your decision-making process. Unconscious bias exists for all of us. Carefully examine your decisions and judgments by asking whether they would be different if the witness, lawyer, or person on trial were of a different race, age, or gender. Remember, awareness that each of us has unconscious biases can actually help us all become more conscious about the fairness of the decisions we make. The more aware of it we are, the better. You'll learn more about all of this when jury selection gets underway in the courtroom. If you have questions, please pass them along to the people conducting your orientation, to the bailiff, or to other court staff in the courtroom. For more than 200 years, our justice system has depended on the common sense and sound judgment of citizens with no stake in the cases. Citizens are called upon to be jurors and to render a fair and just decision in light of the governing law. As jurors, your decisions will be important, maybe affecting the defendant's liberty or millions of dollars. Whatever the issue, remember that each decision matters a great deal to the people involved in the case. What we ask of you is to bring your sound judgment and an open mind into the courtroom so that you and your fellow jurors will be able to render a fair and impartial verdict. The final step in the trial is your deliberation. You'll go to the jury room to begin your work of sifting through all the evidence in the case. During this important process, the jury will select a person to lead your discussion. This presiding juror can make sure you deal with the case in a sensible and orderly fashion, and that all jurors have a fair chance to discuss their views and ask questions. It is important that all jurors participate in the deliberation process. In the jury room, you'll have a copy of the judge's instructions on the law, along with other relevant documents and physical evidence. Everybody will have an opportunity to carefully read and consider the judge's instructions. If an important question comes up during your deliberations that you are unable to answer among yourselves, you may send a written question to the judge. This process may take some time because the lawyers will no longer be in the courtroom and the judge will need to consult with them before answering your question. If you do send a question to the judge, do not indicate in any way the status of your vote. During your deliberations, if you think that anyone on the jury, including yourself, has arrived at a judgment shaped by unconscious bias, you must bring this to the attention of the other jurors so that it may be fairly discussed among all members of the jury. Honest, intelligent, good people are impacted by unconscious bias every day. Upon reaching a decision, you'll be asked to return to the courtroom. The judge may ask the presiding juror to announce the verdict, or the judge or clerk may read the verdict aloud. Thank you for taking the time to consider these issues. You're about to become part of the most important tradition in our justice system, the right to a trial by jury. Your service and your effort are part of how we ensure everyone receives a fair trial. Your willingness to devote your thought, your energy, and your humanity to jury duty says a great deal about you. You care about your community, and your participation gives real meaning to the democratic concept of a government of the people, by the people, and for the people. Thank you.